Now, Samsung Electronics was dealt a blow when a California judge issued an injunction banning sales of the company's Galaxy 10.1 touchscreen tablet in the US at the request of Apple. The preliminary injunction is the latest twist in the ongoing legal battle between Apple and the Korean technology group. Brian Wimpey, director at Norton Rose, joins us in studio for more. Well, obviously it's legal, because otherwise it wouldn't have happened and they wouldn't have ruled in favor of Apple. But it is a little unusual, and that's a tight control over a patent, isn't it?
I'm not sure why you say it's unusual. There are often patent battles about products, and this battle has been brewing for a while. I believe it started back in 2011, and there have been ongoing battles all throughout the world. And what has happened now is that Apple has obtained a preliminary injunction, but it's dependent on the matter going to trial at the end of July. The problem that as we sit here in South Africa, we don't know, and in fact a lot of people in America don't know what the basis for the injunction was, because most of the records in the matter are sealed. It often happens in matters where technology is involved or where new things are involved that the attorneys ask for the records to be sealed. So we don't know what the precise nature of the patent is, whether it is a patent that Apple depending for its rights on, or whether in fact what is known in the States is a design patent, which is really the look and feel of the thing rather than its functionalities.
I think that's what I was referring to as unusual, is that technology's commoditized. I mean, we're moving, if you look at all the devices, everything is moving to the same look and feel, and you would have expected competitors to come up with a similar offering to the iPad.
Absolutely. If you look at all the smartphones that are out there, they all have touchscreen technology. One of the issues that was raised in the research I have done on this matter is I thought for a moment that it was the human interface technology that perhaps Apple were upset about. But either the judge, Cohen, I can't remember, I think it's Cohen, or one of the reporters said that it seemed to be something to do with the look and feel of the tablet. That I can almost understand, because design protection as opposed to patent protection is for a visual appearance of something, okay, rather than its functionality. So why they speak about a look and feel and at the same time they talk about a patent case, I'm not sure. But it may just be because in the US you get a patent design and then you get a utility patent. Okay, so you get two types of patents. In South Africa we'd call a functional thing a patent, for example a process, a technological process. You'd file and obtain patent protection. And the look and feel of something would be subject to design protection in South Africa. It's just a different way of defining these things.
Where do you guys stand on the news flow here?
Well, it's difficult to say because we're limited to actually know exactly what's going on. And it's interesting because over the last few years, it's clear that the way Apple has evolved with its business model and the acquisitions that are taking place in the US, that patents are extremely valuable. And we're running into billions of dollars. And Brian, I wonder what your take is on. Do you think the patent regime in the US and also globally is best suiting innovation and consumers, or do you think this is just the nature of the patent regime that we find ourselves?
It's building a moat around a company that nobody can break through.
Well, that's part of business. I mean, we have to go back to basics. IP, in other words, trademark designs, copyright and patents, are limited monopolies in a capitalist world, because essentially we're in a global capitalist world. I'm sure you gentlemen will agree with that. And what you're doing with all of these IP rights that you get is that you're granting an innovator a reward, saying, okay, but because patents are only valid for 20 years. So what you're saying to Apple, say, if you've got a valid patent on whatever it might be that you've innovated, you've got 20 years to get your reward, and you've built yourself a monopoly around it to keep the competitors away for that period. After that, it becomes free for all. So your question, I don't know. If you had to get rid of, let's say we wake up one day and every country has decided to get rid of monopoly laws relating to IP rights, does it mean that there won't be an incentive for innovators to spend their time and energy? You look at the drugs industry. I'm talking about pharmaceuticals, not recreation. It takes them sometimes 10 or 15 years to develop a drug to the stage where they can actually put it on the market. Are you going to reward them for that time? Or are they, as soon as they put it on the market, their competitors take it,
break it up.
They break it up, they retro-engineer it, put it back on the market? Those are philosophical questions.
It's very philosophical because the drug scenario is far more pertinent. Should
Much
a
more
company
pertinent.
be allowed to commercially benefit while people are dying when there's a drug that could potentially save their lives?
No,
And
that's a different
I don't
discussion
have
for
the
a
answer
different
for
night.
that.
I think
But so my
don't have the
question wasn't to
answer
do
for
away
that.
with patents completely.
Yes.
What do you think in the patent
What
regime
restrictions
can be?
there should be on things like that?
Yes, what can be tweaked in order for it to perhaps work more efficiently?
I don't think there's anything inefficient about it.
Okay.
I mean, Apple won't tell you it's inefficient. And
No,
nor will
Apple will
Samsung,
tell you it's
because
incredibly
Samsung,
efficient.
exactly, and Samsung have got its own patents. And let me tell you, Samsung have their own cases against Apple elsewhere. So this is, and if I had to look into a crystal ball, there's going to be a settlement somewhere along the line, because otherwise this is going to go on when my grandkids are in school. They're still going to be fighting about this somewhere. But your question, I don't know. If you want to talk about is it just, that's a different story. It's got nothing to do with this.
I think if we just look at it from the outset, I mean, even just looking at your tablet on the table here, I'm sure the viewers can't actually tell whether it's a Samsung or an Apple.
No,
but,
they can't.
But if you just look at the patent laws around the products, these patent laws, are you in agreement that they're probably a little bit too stringent? Because what it's actually doing in the big picture is it's eliminating competition that could potentially, benefit the consumer at the end of the day.
Exactly, it goes against free market economics.
That's why it's a limited monopoly. That's the whole point. They're giving a monopoly for 20 years. But the thing is, the trouble is we're arguing here in generalities. We don't know what rights Apple claim in this. So we don't know. It might be something small that Samsung can then avoid by bringing out a different model. So it might, in effect, encourage innovation by Samsung. I think the problem really is that the world has got so fast and so digitalized that there's so much going on. And it's very difficult not to infringe somebody's rights. But that's why we're there. I mean, isn't that why IP Turn is there? So you can come to me and say, look, if I design this, am I going to be in trouble? And I'll tell you yes, no, or as a typical attorney, I'll say maybe.
And a typical economist as well, put them in the same camp. Brian,
Yes.
thanks so much for your time. Just out of
It's a
interest,
pleasure.
are we looking at an iPad or Samsung there?
This is the tablet, 10.1, the subject of this particular case.